Hey everyone, welcome. Thanks for joining us a little late in the day. I'm Katherine Franke. I'm not teaching this semester, but I will be teaching one of the 1L electives in the spring, and I hope to see a bunch of you there. Critical Legal Thought. And I am joined today by these wonderful colleagues of mine who are teaching in the first year foundational curriculum this semester and next semester. I think kind of a mix. And yeah, please have a seat. I remember being in my 1L year a little while ago, but I've also heard from 1Ls and 2Ls since then and more recently that there's this sense that the first year curriculum seems irrelevant. Why do we have to do it? I'm not interested in X, whether it's contracts or torts or property or whatever. I want to be a lawyer that does Y. Why do I have to do X as part of my basic legal training? And so part of what we wanted to do today is a little bit like speed dating with a particular focus, which is to go through the first year curriculum through the lens of abortion and reproductive justice so that you can see what the stakes are for the courses that you're taking in the first year curriculum around this issue. And there are many stakes, whether it's property contracts, torts, civil procedure, criminal law. Did I get everything? Con law, of course. Con law is a kind of easy one because that's how abortion rights gets teed up as a legal matter. And Professor Pozen will talk about some of the more complicated con law questions. But probably you haven't thought of abortion, reproductive justice, sexual liberty, reproductive autonomy as an issue that implicates property law, torts, contracts. It's got civil procedure all over it, right? And hopefully you're lucky enough that you have a civil procedure teacher who's raising those issues in the class. So what we're going to do is go through each of the first year curriculum classes pretty quickly and save a little bit of time for your questions. And please do ask questions. So I'm just to get us started, I'm going to do torts. I'm not teaching torts this year, but I have in prior years. Professor Maeve Glass will then pick it up and talk about property. Professor Olatunde then civil procedure. Professor David Pozen will do constitutional law. And then Professor Sanger, who's remote but will be with us, will be talking about both contracts and criminal law, which you don't often think of the two together. But in this context, they're very much related. So each of us is going to talk about 6 minutes. It's not that long. It goes very quickly. And you will hear me do this because to give us each a little sense that we've reached the 6-minute mark. And I'm actually going to time myself because often you don't appreciate that 6 minutes has gone by. But first, really quickly, how many of you are 1Ls? Oh, great. Most of you. Terrific. Okay, good. So let me start with torts. So as torts is taught, how many of you have torts this semester? Okay, and a bunch of you are going to get it next semester. So torts is commonly understood as a subject that is about wrongs between strangers, right? Car accidents, that kind of thing, where you sue because you've been injured by somebody you don't know. And we have two types of torts, negligence and intentional torts for the most part. So you do it by accident, you injure somebody by accident. There are certain scenarios under which you could get compensation for your injuries, or somebody intentionally harms you, which is of course worse. And you can get civil damages for intentional torts as well. There are a ton of legal claims that have been brought in the abortion and reproductive justice space that show up as torts claims. And I'm going to give you the names of a few of them and then talk about two specifically. The first is the tort of wrongful life. It's an ugly tort, right? Often we think about wrongful death, that somebody is, you kill somebody or somebody is killed as a kind of tortious conduct, that they either negligently or intentionally killed somebody, and it's brought as a civil damages claim. But there is such a thing called a wrongful life claim. Basically, I should not have been born, right? And there's a long history of wrongful life claims that you can imagine, many more of which could be brought now as access to abortion and contraception is becoming much more difficult in so many parts of this country. And I used to teach disability law, and we would teach the wrongful life cases as a fundamentally offensive tort that, say, somebody is born with a particular physical or mental impairment, and that perhaps a doctor didn't diagnose a missed amniocentesis or some other kind of screening during pregnancy. And actually, there are claims where people with severe disabilities have sued for wrongful life and won. It's an ugly tort, definitely, but it is still a tort in many states. A second, which I'll just mention, has to do with abortion outing. You know, Operation Rescue and many of the anti-choice social movements show up at clinics like Planned Parenthood and elsewhere, write down license plates, take pictures of people, pose as escorts to help people go into a clinic, a reproductive health care clinic that might be providing abortions. You might also be going for a pap smear or some other kind of reproductive health. And then they get your name, and then they publish your name on the internet or elsewhere as a way to shame you from accessing or obtaining the full spectrum of reproductive health care. You know, that can be humiliating. It can be horrible. It's a private thing for many people, and in the climate we're in right now, being outed as getting an abortion may be something that is very damaging to a person's reputation, to their relationships, to a whole range of things. So there are two torts that have come up under, that people have brought against abortion outers. One of them is called an intrusion tort, which covers wrongful intrusions of a person's physical seclusion or personal affairs. And the other is a publication tort of basically publishing private facts about a person. And this may only show up in the notes in your torts casebook. They usually don't, these sorts of publication or intrusion or privacy-based torts don't take up a whole lot of the torts curriculum, but they do exist. So the two I really want to spend time on a minute are, first, defamation. There's an active defamation case going on in Indiana right now. 3 days after Dobbs was decided last June, it came to be known to a doctor in Indiana, Dr. Caitlin Bernard, that there was a 10-year-old girl who was pregnant in Ohio. Right? And Ohio had just criminalized, right after Dobbs, they had one of these trigger laws. They had criminalized any termination of a pregnancy after 6 weeks. And this little girl was 6 weeks and 3 days pregnant. So a sexual violence organization was able to get her out of Ohio and Indiana. Dr. Bernard did the abortion, and the Indiana Attorney General and the Office of the Attorney General, but the Attorney General himself went on Fox News and said, "We have this abortion activist acting as a doctor with a history of failing to report. We're gathering the evidence as we speak, and we're going to fight this to the end, including looking at her licensure. If she failed to report it in Indiana, it's a crime." It's actually a Class 5 felony, to not report and to intentionally not report. They knew that was false. They knew she wasn't an activist posing as a doctor. They knew she didn't have a history of not reporting medical procedures that the state of Indiana required her to report. So she sued the Attorney General and the Office of the Attorney General for defamation per se. So there's certain kinds of defamatory false things that you would say about somebody knowing that they're false, that are presumptively injurious, and damages are presumed in a defamation per se case. And two of the contexts where defamation per se applies are around illegal behavior or behavior incompatible with your business. Oh, damn. So I have another really good one from the Dobbs argument, which Lily has teed up, but I'm going to model restraint and not do it. But it has to do with an argument that questions from Justice Thomas it wasn't Dobbs, it was the SB 8 case in the Supreme Court, where there was a question about, well, what injury had some random person who SB 8 allows to report that somebody has performed an abortion, what kind of damages have they received? And the answer from the Attorney General of Texas was the tort of outrage. right? Basically, I am outraged that somebody I know who was pregnant received an abortion and therefore I have been injured. And you'll learn a lot about bystander injuries, emotional injuries, both of which are typically not compensable in most jurisdictions as torts, except Texas in the context of abortions, where you're outraged that someone received an abortion. Professor Glass. And I think, yeah, this is on.
So thank you so much, Professor Franke, for organizing this. Thank you to Lily for putting it all together, and thank you for being here today. So I teach property, although I also teach constitutional law, and it's nice to see many familiar faces. Today, I wanted to start by asking us to step outside of 102B and travel back in time and across the country. The year is 1988, the place is Los Angeles, and the judges of the Court of Appeals have filed in for a case that they announce is given them reason to be cautious. The dispute that they've been asked to decide began some years earlier when a man who had cancer went into UCLA Medical Center for treatment. The doctors, after removing his spleen, discovered that they were looking at cells that would eventually be worth upwards of $3 billion. The doctors, without telling the patient, patented a cell line and went on to remove tissues for the next 7 years. When the patient learned of this, he filed the suit that was being heard on appeal in the Court of Appeals of the state of California. And the question before the court that day was a simple one. Did a person have a property interest in their body? And in answering that question, this question that had given the court pause, the judges answered with a resounding yes. A person had a property interest in their body sufficient to sustain a claim of conversion, which is a tort, sufficient for the case to proceed. Now, as I was telling you that story, I saw some people's heads nodding. Does anyone remember the case that I might be talking about? You can say it in unison or for interest of time. Moore versus Regents, yes. So if you haven't had property, one day you too will be able to recognize those facts and say this is about Moore versus Regents. But the case that I told you isn't the case that's in the case reporters. The case that we read in our property case books is actually the decision that came next when the Supreme Court overruled that decision, finding no, there is no property interest in a person's human tissues sufficient to sustain a claim of conversion. So in the 6 minutes that I have, which is probably now 4 minutes left, I want to take that case that isn't included in the case reporters to tee up why I think it illuminates just how central property law is to the struggle for reproductive justice that's unfolding today. Now, full disclosure, this is not my original idea. Professor Julie Suck has written a fabulous article that's coming out that builds on this idea. Actually doesn't build, she introduces the idea. So I'm just channeling her, and I'll share the opinion after this. Essentially, here's the key three takeaways. Number one, the Court of Appeals decision reveals the enormous stakes of recognizing a property interest in a human tissue. At stake in the Moore versus Regents decision was whether or not Mr. Moore would be able to proceed with his claim of conversion and get a share of the profits of upwards of billions of dollars. That reason, the reason why property has that power is because property isn't just a material object. Property law is a set of rights that allow the owner to exercise the right to exclude others, the right to use, the right to compensation from loss. So the key first point is that recognizing a property interest in human cells automatically triggers a whole set of corollary rights that would allow a person to exclude. And for our purposes today, I'll just name one of the takeaways, it would potentially allow for people to seek compensation from states that have banned abortion. Why? Because of the takings clause, which in property you'll get to at the end of the semester, that says that if the state is taking your private property for public use, it owes just compensation. That means that if we were to follow the Court of Appeals in Moore versus Regents and extend a right of property in one's spleen to a right of one's uterus, it would follow that the state would have to pay people who are carrying unwanted pregnancies for their lost wages, for their emotional, physical, economic costs that they would burden. Now tally up all those costs, and what you start to see is you're internalizing the costs that a person who is carrying an unwanted pregnancy back to the legislature. With enough takings claims, you might begin to see a recalculus of the costs of an abortion ban. Okay, so point number one, just enormous power. Point number two, and this will tie into point number three, is the limitations and the potential concerns for recognizing that property right. So I've just given you the biggest version of this, right, would be that states are actually having to internalize the costs until we see abortion bans dispensing. But what's at stake in pursuing a property rights approach? The Court of Appeals, when I started with that saying that they were cautious about this, they were cautious because it means that you'd have to recognize a commodity in one's body. Now, the Court of Appeals avoided that concern by saying there is a distinction between a right in one's own person and the right to own another person. But we still might be concerned if we start thinking about what it means to commodify a body. Second reason why we might be concerned, so we've got the big vision, number one, do we really want to be commodifying bodies? Second reason we might be concerned, do we really want courts to be relying on precedents that are incredibly malleable to find that common law right? In property, we'll talk a lot, well, not we, but we talk a lot about should courts be creating these rights or should legislatures? In the Court of Appeals, the court stitched together this right by looking at a whole set of precedents about the right to feces and dying bodies and dead bodies and corpses. Is that what we want to base a right on? And then lastly, just for 2 seconds, the last reason why we might be of concern is because what does it ultimately mean that we're basing the right to property in one's person, not through a recognition of what it means to have claimed property in someone's reproductive labor? Our property system is built on the extraction without compensation of reproductive labor for centuries. Do we really want to be going back to that? So that's a snapshot of why I think property, which often flies under the radar, has a lot to tell us, a lot of questions to ask about what it means to recognize a property right and what are the potential trade-offs and complications of that move.
Thank you. That was fantastic. Professor Johnson.
I just want to say I'm already so stressed out about the time. It's not that I was planning on talking so long at all, but I just see how quickly it all goes. And
Take
but
your
I
time.
also
We'll circle back. So
no, it's okay. I also could have listened to both of you forever. It was a really interesting way to think about the connections. So I teach Civ Pro, and I think that there are so many connections between abortion and Civ Pro issues. Some of them kind of startled me in a way. First of all, I know that everyone is in Civ Pro or took Civ Pro, so we have a common baseline of things to talk about. So coming into the class, I remember last year when SB 8, the SB 8 Texas case was decided, it was being argued before the Supreme Court, which raised the issue of whether you could have a private enforcement action, as was mentioned, that it in fact interfered with someone's right, what was then a right to have an abortion. It raised lots of interesting issues for me because a lot of my work is focused on private enforcement. And I think at the intersection of legislation and civil rights and civil procedure, and I generally think of private enforcement as a way of enhancing state capacity. So it really presents a conundrum. Why is it a bad thing to enforce, for example, the Fair Housing Act, or we have key tom statutes that act as bounty hunters, where private individuals can enforce on behalf of the federal government. So it raised interesting questions about what's so improper about SB 8 if you like other kinds of private enforcement statutes. The line you could easily draw at the time was that they were asking you to privately enforce something that they would never publicly enforce, because at the time abortion was constitutional. So it was very different from other kinds of private enforcement statutes. The second thing, though, way it's come up in Civ Pro this year has surprised me more. Dobbs is in the air when we're talking about courts, full stop, in a way that I hadn't expected it to be. So we talk about cases about the enforcement power of courts. Courts don't have armies, right? So they enforce through contempt orders and sanctions. And so that raised questions around when can we disobey court decisions, and hanging over the students and different ways of talking about these issues this year, because people are thinking about questions around the legitimacy of the courts and the power of the courts very differently this year than we had in past years. So I think for me, we haven't in my class come to thinking about the structure of the federal courts, term limits, independence, size of the courts. I've never taught that in a first-year civil procedure class, but it seems very urgent to teach those things this year, and we're going to teach them, and I hope you're exposed to them in all classes. I guess the last thing I want to say that's concrete and doctrinal is just the place where I put Dobbs and post-Dobbs work into the curriculum was around preliminary injunctions, and maybe you have this experience in other classes. In past years, I use a current issue to teach about preliminary injunctions. Of course, you know that's about getting relief before a final judgment. You have to meet a 4-factor test, and generally irreparable harm and likelihood of success on the merits are the most important, although the courts engage in balancing and think about the public interest. And in past years, I've done this around election law, and this year I chose to do it around a decision in which the United States sued Idaho for having a complete abortion ban that the United States said conflicted with an emergency. It's called EMTALA, okay, but it's an emergency statute that essentially says you can't, that if you receive federal funds, you have to be able to give emergency care, including in cases of pregnancy, distress, abortion. And so the United States sued Idaho because it had a complete abortion ban that only had an affirmative defense for death, not even sort of for grievous health problems. And so, so the court in this decision that we read said there's a likelihood of success on the merits the United States has on its preemption claim. And then said also that when you look at the irreparable harm and the balance of equities, they're in the favor of the United States. And so what is the harm? The harm is to the sovereign interest of the United States because it wants to enforce its law. And also says there's a harm to physicians who might be arrested or, you know, in jail or fined because they're violating the law. But it also said, and I just want to read it, the court said, found that allowing the Idaho law to go in effect would threaten severe irreparable harm to pregnant patients in Idaho. Speaking of patients, although the parties in the court have often focused mainly on the actions and competing interests of doctors, prosecutors, legislators, and governors, we should not forget the one person with the greatest stake in the outcome of this case, the pregnant patient, lying on a gurney in an emergency room, facing the terrifying prospect of a pregnancy complication that may claim her life. One cannot imagine the anxiety and fear she'll experience if her doctors feel hobbled by an Idaho law that does not allow them to provide the medical care necessary to preserve her life and health. And so you could think about different ways that could have come out. There's actually a Texas decision that's a little bit different. I don't have time to go into all of the differences, but it involves Texas suing the United States and claiming a preliminary injunction to enforce its law. And its law is different from Idaho. It has more exceptions for health and life and explicitly segments ectopic pregnancy. But the court in that case made a different kind of calculus. It really credited Texas interest, its sovereign interest, its interest as a state in enforcing the law. And it didn't really mention at all the interest of a pregnant patient and the health and life of the pregnant patient. And so you see how we try to engage questions in our class, although we never have enough time, as students know, to really think about whether in the Idaho case, the court didn't balance Idaho's interest. In fact, the court says at the end that the state of Idaho won't suffer any harm. And there's a reason that you can justify that position, because Idaho said we weren't trying to harm people in emergency care situations anyway. And so that's the basis under which the court said there was no harm. But you see very different approaches as to whether or not the state has an interest in unborn life and whether it has a broader interest in enforcing its law. So there, in giving that example, I was not only able to get in preliminary injunction, got a little bit of statutory interpretation and leg reg, which you will hopefully take as your elective in the spring, and a little bit on federalism, which links to some of the con law issues.
Okay, thanks. Well, I'll try to be quick. Constitutional law takes up abortion very explicitly, so it's differently situated from the other subjects. In particular, the question, does the federal Constitution provide a right to abortion? As you know, in Roe versus Wade in 1973, the Supreme Court said yes, that the right of privacy, as it described it, founded in the 14th Amendment's concept of personal liberty, or what we now call substantive due process, is broad enough, I'm quoting the court, to encompass a woman's decision whether or not to terminate her pregnancy, end quote. The court further elaborated and narrowed the right to abortion in numerous cases following Roe, most notably Planned Parenthood versus Casey in 1992. Justice Ginsburg suggested that the right of abortion might have been better located all along under the Equal Protection Clause, not under the Due Process Clause, but that never picked up 5 votes. And now, of course, Dobbs has overruled Roe and Casey, and we have no federal right to abortion under the Constitution. That's a whole unit in most, I was, speed round, but that's a whole unit in most common law classes, certainly in mine, in which you walk through the succession of cases following Roe and interrogate that question. It's the headline issue. Does the federal Constitution protect abortion? And if so, what sorts of state restrictions on abortion are permissible? Let me just suggest that in light of Dobbs, there are numerous other common law issues still in play. And I'll just give some illustrative examples, by no means an exhaustive catalog. I'll suggest 5 areas that remain open now that are going to be litigated and contested for years. Okay, 1, does Congress have the authority to impose a nationwide abortion ban, or conversely, to pass new laws that protect abortion access nationwide and preempt conflicting state laws? Well, the constitutional question is, what authority could Congress claim to pass such a law? And it can't be the authority to enforce the Due Process Clause or the Equal Protection Clause themselves under Section 5 of the 14th Amendment, because we now know from Dobbs they don't protect abortion. Congress in the past has relied on the Commerce Clause. Students in my common law class won't be surprised to learn. The workhorse of Congress' congressional authority under the Constitution to pass almost all of the nationwide rules it has set previously on abortion. For example, the Partial Birth Abortion Ban Act of 2003, which is a federal law prohibiting this procedure that is termed partial birth abortion. It's not, I think, a fair term, but I'm going to quote the statute. It says, any physician who, in or affecting interstate commerce, performs a partial birth abortion shall be fined or imprisoned, ... That was always a kind of weird understanding of the commerce power. What does it even mean to perform an abortion in interstate commerce? Congress never clarified that. There were numerous skeptics of that theory of the Commerce Clause, but the Supreme Court never ruled on that issue. That was a federal law restricting access to abortion, and the conservative court didn't seem interested in interrogating the Commerce Clause, viability of the law. I predict that if there's new federal laws expanding access to abortion rather than restricting it, the court may get interested in whether the Commerce Clause can, in fact, authorize such legislation. Okay, so what can Congress do? Second, what can state constitutions do, even if the federal Constitution has dropped out of the picture for abortion rights? Every state constitution in this country has its own equal protection and due process clause cognate to the federal clauses. State courts have tended to interpret them symmetrically to the way the federal courts have interpreted the federal due process and equal protection clauses. They don't have to. They could depart from the federal understandings of the federal clauses. And indeed, just last month, as you may know, a Michigan lower court judge made national news in interpreting the Michigan due process and equal protection clauses under the Michigan Constitution to strike down a state abortion ban. So are we going to start to see state constitutional law pull away from federal constitutional law and doing more to protect abortion rights, particularly in blue states? Okay, third, interjurisdictional issues. In particular, to what extent can a state impose civil or criminal liability for out-of-state travel to receive abortion care or for the facilitation or provision of such care? Justice Kavanaugh, as you may know in his concurrence in Dobbs, said the following: may a state bar a resident of that state from traveling to another state to obtain an abortion? In my view, the answer is no, based on the constitutional right to interstate travel, end quote. Justice Kavanaugh cited nothing for that proposition, and let me just suggest that it's not clear. I'm kind of glad that he said that, but it's not actually clear under the doctrine as it exists today. He said a state can't outright prohibit someone from leaving the state to get an abortion. But actually, there are many, many more complicated cases. What if a state doesn't outright bar travel to another state, but penalizes conduct that occurs in another state? With medication abortions, where exactly does the abortion occur if the medication was mailed from another jurisdiction and used within a state in which abortion is illegal? What if you travel out of state to get the medication but come back in state for the abortion itself? Difficult conceptual questions about how to even think about where abortion's happening in the age of medication abortion. Can out-of-state senders of the medication abortion be prosecuted in the state in which it's used and is legal? There's a great article I'll just commend to you coming out in the Columbia Law Review. It's already online. I wrote down the title, The New Abortion Battleground, that you can easily find online that canvasses some of these emerging interjurisdictional issues. The authors of that piece take the view that the best reading of the Constitution's right to travel, plus the dormant Commerce Clause prohibitions on states imposing burdens on interstate commerce combined mean that states shouldn't be allowed to do too much extraterritorial regulation of abortion. I personally agree with that position, but even the authors of that piece have to concede that the doctrine is underdeveloped on this point and unclear, notwithstanding Justice Kavanaugh's protestations. The one thing that is clear is that any notion that overturning Roe and returning abortion to the states would cool down the temperature of abortion debates and facilitate compromise is utterly false. And in fact, it's inflamed conflict. Fourth constitutional issue still open, and the kind of nightmare for abortion rights advocates. Dobbs doesn't say that Dobbs says the federal Constitution doesn't require access to abortion. Could the Constitution prohibit access to abortion such that any state law allowing abortion is itself unconstitutional? Justice Alito says we're not going there. We're not talking about that in this case. Justice Kavanaugh says something similar. But many on the political right are pushing in this direction under a theory of fetal personhood, as they call it, whereby policies that allow for abortion would be seen as violating the substantive due process right to life of the fetus, understood in this conception as a person. This has not yet been tested in litigation, but the National Right to Life Committee and other anti-abortion groups are certainly pushing in this direction. Fifth, and this got a lot of attention after Dobbs came down, will Dobbs, in its understanding of substantive due process, spill over into other areas of substantive due process law, such that the right to contraception or the right to same-sex marriage will be overruled as well? Kavanaugh again weighs in on this in his concurrence and says, "Don't worry, we're not talking about those cases. They're still good law." But conceptually, some of the moves made by the Dobbs majority certainly would seem to undermine them, although politically they seem safer at this moment. Let me close by suggesting one other thing in a different direction, which is kind of the converse of the fear about how Dobbs may spill over and limit other rights. At the moment that Roe came down and a right to abortion was announced, actually something of the opposite was happening. I've been looking at this, a project I'm doing on the constitutional history of the war on drugs. When Roe came down and announced this right to privacy along with Griswold before it, actually lots of people all around the country did not understand Roe as just about abortion or Griswold as just about contraception. They said, the actual language of these opinions is right to privacy, and also language about liberty. And those are much broader concepts that can be applied to all kinds of things, including, turns out, right to personal drug use and possession. Does that sound crazy? The ACLU took this position in 1968 and then the 70s after Roe came down. The California Senate issued a report in 1974, and I quote it, that said, Roe compels the conclusion that the right of an adult to possess and use marijuana in private is an act falling within the ambit of the fundamental right to privacy. Roe compels the right to be allowed to use drug use. There was a moment in the 1970s in which Roe could have been profoundly jurisgenerative of a much broader conception of privacy and liberty. And the case law started to go in this direction. In the end, the federal courts in the 1970s made two big moves to limit Roe's potential to open up privacy and liberty claims in many other areas of life. One, they said privacy and liberty claims need to reflect a fundamental interest. If you don't have a fundamental interest that's been abridged, then we're not going to take seriously your substantive due process claim. And most of these other sorts of claims, like drug rights, were called non-fundamental. And second, Roe and Griswold were redescribed as being all about procreation and reproduction, and just about those things. So they were not about the right to be let alone, or the right to control one's body more broadly, or the right to make one's own decisions on sensitive personal matters. No. They're just about procreation and reproduction. They were limited in that way. In short, there was a time when Roe could have done more, and there may still be a time when it could. But in three phases, I see the court as having led us to this point. First, I'll just end on this. Roe and Griswold were described as not standing for broad liberty or privacy rights or equality rights, but rather being specifically limited to procreation and reproduction. Second, Roe itself and the abortion right it announced was curtailed. Well before we got to Dobbs, the Roe right was shrinking dramatically. And third, Dobbs just ends it all. So we've gone through a 50-year cycle from Roe, being told the next year by the California Senate that obviously it protects a right to use marijuana, to where we are now, where Roe doesn't survive. Sorry to end on that bleak note, but yeah.
Okay, we have Professor Stanger remotely. There she is.
Hi there. Can I be heard? Can you hear me?
Yes.
Okay. I'm here representing the contracts phalanx of our 1L faculty, even though I'm not teaching it this term. And I was going to give you two examples, but I'm following Professor Franke's lead and starting out by saying I'm taking one of them away right now, since we're never going to get there. But I do want to tell you what it is. These are two ways that contracts have interplay with abortion. The first is something that's a lot of work is being done on right now, and it concerns surrogacy contracts. So, gestational surrogacy, when a couple wants to get a baby and they hire a woman, probably in the Ukraine, to gestate the baby, and then she turns it over. Now, one of the things that lawyers have been doing is putting into the contracts between the surrogates and the would-be parents a clause saying that if the child is born or is detected to have certain kinds of anomalies, physical anomalies, and not be well, the commissioning parents have the right to order her to abort the child, because that's not the child. They're putting in kind of like a quality control mechanism. Someday this will all be before the UCC, I'm sure. But there's a lot of work being done on that about is that constitutional? And we would have said, and so it'll be very interesting to see how those cases are handled. The things are different physical handicaps. In one or two cases, it concerns the numbers. Like if you have multiples, twins, and parents only wanted one kid, can they require an abortion then? So anyway, that's the one I'm not talking about, but that you might be interested to investigate it. And there are lots of open questions about these contracts. Are they enforceable at all? If they're not, what good do they do? And the answer to that by my lights is they scare the bejesus out of the surrogate mothers who aren't as sophisticated and think they have to abort. Okay, we'll leave that. The one that I want to look at is demonstrates one of my favorite things about contracts. And that is, you've probably all heard the phrase private ordering, or I hope so. Are there any hands or heads nodding or hands up or anything? Private ordering. And so let me situate it this way. We start out, we know that the law is all into bossing people around and getting them to behave in certain ways and not behave in other ways. And we start with criminal law. You know, those are the kinds of behavior we have the greatest opposition to, and you can be punished and fined for engaging in criminal behavior. The second is what Professor Franke already mentioned, negligence. We don't want people to be sloppy and harm other people through their careless behavior, or sometimes their intentional or reckless behavior. And so there we say, well, it's not as bad as criminal law, but we don't like it. We have a policy against this kind of harmful negligence. And so you can have a civil action against someone who harms you negligently. And I wanted to just mention, along others, the new book, relatively new book out by a guy at San Diego named Dove, D-O-V, Fox, F-O-X, just on reproductive negligence. That's pretty, oh no, it's a book and it's an article in the Columbia Law Review, which a number of us respond to. Okay, but now we come to contracts. The great thing about contracts is it's neither the criminal law nor negligence, but it is a body of obligations which people enter themselves. They decide themselves that they will obligate themselves to perform something in this way, to pay money, to perform a service, whatever it is. And so it has a great deal of autonomy embedded in the very rules of contracts. Contracting is a standard mechanism to secure one's preferences. And what I want to tell you about is a case from Missouri in 1987, that's 14 years after Roe. And it's a case where, oh, and I looked up just, I'm taking out a whole section on the sort of social meaning of abortion, the political economy of abortion in Missouri in 1987. I've got a lot of statistics, how many, about 20% of pregnancies ended in abortion there. So it was not an unheard of thing. All right, here's this case. The plaintiff's name is LG, and she is suing the estate of her father, HAG. She's suing him because before he died, she told him, listen, Dad, she's married, unmarried and pregnant. And she tells her father, Dad, I'm pregnant and unmarried, as you know, and I intend to stay pregnant and unmarried, and I'm not having an abortion. And he says, oh, I think you will be. Why? Because he says, I'm going to take you out of my will if you don't terminate this pregnancy. If you do terminate the pregnancy, I will reinstate you in my will. But as things stand now, I'm taking you out. So she waits a little bit of time. She thinks about it and she says, I don't like this guy. I don't know what she says. We have no information about her whatsoever, but you can make up your own little story. And she says, okay, I accept. And she has an abortion. He dies. They read his will, and he has not reinstated her. So she sues him for breach of contract, and his estate, so you're with me on the facts, like they're not too hard, but now we come to the interesting part. His estate responds, defends itself and him with two arguments. One, they say, there's no consideration. There is no contract here. You can't have a contract where somebody bargains with someone else to perform, to have an abortion performed on themselves. That's an unpleasant thing to do, and it's against public policy. And the other thing they say is, besides, she was necessarily coerced into this decision. Nobody would voluntarily choose to have an abortion unless they were coerced into it. Note that the person who's making that argument is the one that, if there was any, she didn't coerce herself into doing it. But so we have these two things. And I have not spent enough time, or any time, in fact, looking up the judge who decided the case. But he's I assume, an ordinary Missouri judge who's, been in a law firm for a while, and he gets this case, and I have no idea what his politics are. And he says, well, we've really thought this over, and we're holding for the plaintiff. There is every reason in the world to uphold this contract. She was not, we have no evidence about coercion whatsoever. And then he says, we all know there was a case about 14 years ago that said there was a constitutional right to abortion. This makes it impossible to claim this is against public policy. And so they uphold the case. They uphold they make a verdict for her. And what I think, so there are a couple of things that I want to just leave you with. One is, what if this case came up today? How would a court know whether they could enforce this contract? Would they have to know what state they're in? And if they're in an illegal state, then you'd say, well, of course it's against public policy. Would you say it's against public policy if the state has 3 exceptions to banning abortion, usually fetal anomaly, rape, and incest? Would we say, well, the fact that they put in 3 exceptions means that the state is not completely against abortion? It acknowledges there are moments when we think it's an acceptable and a legal thing for a woman or girl to choose. So we have that sort of question left. But the final thing I want to say, I think I have 2 minutes left, I don't know, is I wrote a book, quite a nice book, called About Abortion. Very nice cover. And in it, the last, and it's quite interesting, aside from the fact that I thought the Democrats were going to win when Trump won. And so some of my conclusions are on the iffier side right now. But in any case, the last chapter of the book is called Normalizing Abortion. And what it asks the reader to do is, imagine if abortion were treated like any other medical procedure, so that you didn't have to go to a separate clinic somewhere else off hospital premises to get an abortion, although that seemed like a good idea when it started. And it would be treated like any other elective surgery or any other non-elective. It doesn't matter, but it would be treated like a medical procedure. And that is the sense in which I mean normalizing. And what I think the LG-HAG case does, it's a quiet little case that, without any fuss about it, nobody knows about this case, it got no attention whatsoever, normalizes abortion and within the realm of contracts, and says, no, of course our normal rules apply to this situation, because there's no reason why they shouldn't. And we know that abortion is acceptable. So I don't know when there's going to be the opportunity next to argue for normalization. I know we have to get by the midterms first and see how that, where that lands, and then see what a number of the states do with their referenda, of which there are 6 who have them for this coming up election. But what I hope you can see in this case is that you learn a doctrine, you learn contract law, and you think, well, that was interesting, or that was boring, or but you have to stay very open-minded about it, so that when a circumstance comes up where it can be useful, even though it's not the one that's in the book, you can pull it out and work with it and find people to work with it with you and make the law work for you. Thank you.
Thank you, Professor Singer. This thought of the surrogate contracts with an abortion clause kind of circles back to where Professor Pozen was too, of if the contracts are in different states, or the people contracting are in different states or different countries.
Mm,
The intentional parents are in Texas, and the surrogate is in, so let's just say another country anywhere. Can you contract to commit what would be an otherwise criminal activity if it's not criminalized in the home state? Like, just so many hard questions.
yeah.
But we want to get your questions. We have just a little bit of time, and make sure that we can try to follow up on some of the thoughts that this may have stimulated in thinking across the first-year curriculum, and the question of reproductive equality, autonomy, privacy, rights more generally. So any questions? Because we could just keep talking. Yeah, please use your mic for the
Okay,
folks at
can you
home.
hear me?
Yeah.
Okay, great. So my question was specifically about fetal personhood. I know we spoke briefly about how it would show up in the constitutional law framework, but I was considering as well in terms of how reproductive justice advocates would approach combating it in the other topics that we've addressed today.
Well, it's a clear issue in torts. Say you're in a car accident with somebody who's pregnant, and one of the consequences of that accident is that the pregnant person miscarries. You could, in a state that would consider the fetus as a person, you would have not only whatever harms there might be related to the loss of the pregnancy, but it could be understood as wrongful death of a human. And there have been a number of those sorts of cases. And I would commend you to the work of the National Advocates for Pregnant Women. This is the sort of work they do all the time, both in a civil tort context, but also a criminal context, where pregnant people who are using drugs or other substances while pregnant, sometimes prescribed drugs by their doctors, have been prosecuted or sued civilly in tort for the thought of the idea of fetal injury or injury to a person who's in a fetal state. I'm not even sure what term to use in that context. So definitely it's a torts issue.
I haven't thought about it in the context of CivPro, thought about it more in some of my companion topics of con law and civil rights, but one way I could see it coming up in federal courts is around standing to sue, and which is kind of, requires some mental gymnastics, but, whether or not a fetus has standing to sue. That would be an interesting question. We don't learn standing in first year CivPro, but if you take federal courts, you would talk more about that, and maybe a little bit in con law.
Yeah, so in the article that I was citing, which I just looked up to make sure, because everyone should just raise, because A World Without Roe, The Constitutional Future of Unwanted Pregnancy, which is by Professor Suk, that's coming out later this year. And she has a really interesting discussion on exactly this question of thinking about the implications of fetal personhood in the context of, say, the type of takings claim that I was discussing. And the thought here is that there's a way in which moving towards a recognition of a property right in a person's uterus actually sidesteps the question of fetal personhood, because it recognizes and in fact builds on the acknowledgement that the state is asking pregnant people to do a lot of labor in carrying a fetus to term. And in fact, the idea of safe haven laws, for example, could be enlisted to show that the state is actually acting as a quasi-legal guardian for a fetus, and therefore all the more reason that people's labor should be compensated. So there's a really interesting way in which, again, thinking about sort of the possibilities of this property rights approach allows to avoid difficult questions of when personhood begins, by just acknowledging that there is a state extraction of, I think Professor Suk describes it as a tenancy without rent, like rent without tenancy in someone's womb, and so that should be compensated, and that I think is is a really interesting way of thinking about the question.
Just say briefly, in con law, where the question is directly engaged, the due process clause and the equal protection clause protect persons. That's the term used. The Roe court said that fetuses have never been considered persons within the meaning of the 14th Amendment, so they don't have constitutional rights. There was a brief filed in Dobbs by Robert George, a Catholic philosopher at Princeton, that got a lot of attention, in which George argued that, well, the court's now originalist, so it should care about the original understanding of the 14th Amendment at the time it was drafted and ratified around 1868. And I've gone and done the research, and people understood fetuses to be persons, George claimed, circa 1868, so you should too. I view this as very bad history and not a plausible understanding of what people thought in 1868, but the move was made. That was an opening volley, I think, of what we're going to see a lot more of, this kind of attempt to reconstruct what people might have been thinking about fetal personhood in the 1860s to launch an originalist move there. Of course, even if the court doesn't buy that the 14th Amendment right now protects fetuses as persons, the Constitution could be amended, or there could be statutes that declare fetal personhood. We haven't yet. Anyway, I think the George brief is worth looking at if you're wondering where this might go in the immediate future as far as constitutional claims of fetal personhood.
Professor Sanger?
I wanted to just say that, we take on these problems as lawyers and trying to find how we can, just what you've heard for the last hour, but you can barely read the paper any day that there's not a doctor who's having to deal with it in real time. And I think this is a good moment for cooperate liaisons between medical and practicing doctors and what we can offer by way of help. But I think that it makes it so concrete that we see these cases coming up, and it's why well, that's enough. Thank you.
Carol, can you imagine a fetus being a third-party beneficiary of a particular contract?
I've thought about it. I was thinking about a fetus. I was thinking about just whether or not, if you negligently injure a fetus, you've injured a person. And if that's where we're heading, I mean, right now, that's not the case, right?
Not this moment, but I haven't checked the internet.
Yeah. Yeah. Well, no, I mean, I think contemplating what it would mean if fetuses were persons is, very interesting kind of science fiction. If you want to take it on board and think about what it would mean, because everybody who has a wanted pregnancy, loves their fetus and considers it part of the family. And we know that's very good and nice, but I think this difference between wanted and unwanted pregnancies is something that gets too often collided and breaks down distinctions that should matter.
Thank you. Yeah.
Thank you all so much. My question is for Professor Glass. I thought the property angle was very interesting, and I had never thought about abortion in that way. I was wondering so it seems like, having a property right over one's body is sort of obvious on one hand, but also very ontologically challenging on another hand. And I guess, given the history of the law considering women as property of their husbands, or women as sort of property, I don't know if that was explicit, as of the state, like women's reproductive labor, sort of women's uterus as being property of the state. Is there any backlash on that argument for either the fathers of babies sort of saying, oh, well, I have a property right, over this baby, and so you need to give birth to it.
I loved how you started that with the question that there's something very intuitive. Of course, we own our bodies, right? I mean, this goes all the way back to Locke announcing, interestingly, in very gendered terms, that a man owns his property. And that was a man owns his body. I'm not getting it right, but the language is a man clearly owns his property. And that was the basis for his theory of labor as the heart of a property right. And of course, at the time that Locke made this clear declaration that a man owns his property, the settled law would have also recognized that a married man owned the property and labor of his spouse. And at the same exact time that Locke is creating this, so too is the transatlantic trade in enslaved people taking off into the scale that had never been seen before. So absolutely, the tension between this clear declaration we have in our property of our persons coexisting alongside with all of the ways in which dispossession and denial of personhood is one I think can cut either way. On one hand, you could argue that the very fact of that history should counsel in favor of a strong recognition now, sort of a reparative recognition of one's property rights and one's person. But there are others, as you point out, that are concerned about sort of what are the spillover effects if we start down that path. And here, if in property, if any of you encountered Radin's arguments about commodification, a concern that there are just some things that are non-commodifiable, that they shouldn't be fungible, because if we start the slippery slope argument of then we're recognizing private property. In fact, there was an article that came out in The Guardian that was responding to an abortion ban by saying, "Are women now private property?" So it's a language that I think from the very beginning has built within it an understanding that some people's personhoods and properties will be recognized at the expense of others.
Did you want to? Oh, no. Okay. Yeah, please go ahead.
Thank you. So one of the new lines of discourse among those seeking to constrain reproductive rights has been comparing America's system to those of other countries. So the argument is, like, in the post-Hobbes world, we're moving closer to other liberal democracies like France and further away from the systems in autocratic systems like North Korea and Iran, and that this movement is a good thing. So I guess my general question is very broad, but how do you all see international law and potentially transnational litigation shaping the next step in this conversation?
Want to start us off?
It's a great question that I don't have a great answer to. It won't directly bear on U.S. constitutional law for the foreseeable future, which is this hermetically sealed parochial enterprise. But you're right, the constitutional trends abroad have been toward greater recognition of abortion access, and we're, as in many areas of our democracy, kind of retrogressing. I guess I'll say that I find spurious that comparison that got trotted out in the Dobbs litigation that suggests that by limiting abortion or upholding Mississippi's law, we would be moving in the direction of other advanced democracies, because these other democracies mentioned, like Great Britain, have universal health care. It's completely different context in which people can get abortion care much more easily and quickly and free. So I guess it seems to me inapt to think about it in those terms. But the current Supreme Court, I'll just say on the why I'm pessimistic, where I started, has been very resistant to looking to international or foreign constitutional norms to inform anything that's happening in U.S. constitutional interpretation. So the idea that in the abortion context, they would take inspiration from what's happening in Ireland or elsewhere is implausible unless we get new justices.
I'll say something that's not really about Civ Pro. It's really about wearing the law and social movements hat that I think is an interesting place to put this conversation. One of the things I noticed in the amicus briefs, that some of which were talking about what was happening internationally, were who the amici were. So they were purported to be groups that were opposing abortion rights in the EU. And then you look at them and you trace them and you find that they are actually started by the people who are opposing abortion rights in the United States. So there's a kind of transnational, you could think of it as kind of grass tops or sort of manufactured. You don't know how big those constituents are, but it just shows how there's a reach to these social movements, or at least to these organizations, these funding apparatuses transnationally. And it's just something to be really attentive to. And then relatedly, and maybe you could say on the other side, reproductive justice movements right now have been having a conversation about this reframing that we've alluded to connect reproductive rights issues, abortion issues, to healthcare, maternal health, and to family supports more generally, and have drawn on Ireland and Mexico and places where the conversation about abortion was embedded in a larger conversation about maternal health. I mean, the way even the Carol Sanger, Professor Sanger, when she gave her various examples, it was really clear how there's a spectrum of decisions around the choices to be pregnant and not to be pregnant, to carry a child, not carry a child, and the sort of critique that has often been there, especially from women of color organizations, is that the framing of abortion rights doesn't represent that full spectrum, and that you have to honor the right to, and the kind of a choice to have a child needs a social condition. So I think it's really interesting that contemporary groups are looking a lot to places like Ireland and Mexico, where it was framed within that narrative. So it doesn't answer your question from a legal standpoint, but more from a social movement standpoint.
Lilia, when are we doing that panel with the advocates from Chile and Mexico? And
I'll tell you when.
oh, right, Carol's on the panel.
I'll tell you. Oh, it was yesterday. So.
I know you want to talk. Hold on, let me pull you back up.
This will be discussed, I guess.
Yes, it will.
Katherine, I just wanted to, is someone speaking now?
You're speaking, and I'm just doing my best to bring you up. So.
Oh, thank you, thank you. The event, it's sponsored by Gayatri, and it's on the 25th of October from 1 to 4 in the afternoon.
26th of October.
And just two things. The people who registered online were able to receive the materials that I brought, which is just the case, the Missouri case, and then some material on surrogacy contracts. And Lilia said that she would put her own. Lilia, what were you going to do to make it available to people in the room?
I'll say something about that at the end, because we all have cases, so yeah.
Okay.
Yeah.
Well, so but the thing I wanted to respond to was the man who asked about using international law. And I don't know do you recall which one of our senators put up the proposal for a nationwide ban?
I'm directly referencing Lindsey Graham's.
Yeah, that's no. Well, was it then Lindsey Graham who said that he responded by saying, well, Germany has the same period as Mississippi does in the Dobbs case, something like that. Is that what you're thinking of?
Exactly.
Mm-hmm.
Yeah, and it's because the position, like in Roper v. Simmons, which was a child, can you execute juvenile case, the court said, we don't pay attention and we don't pay attention to international law. That's not our thing. And Scalia has that was what his dissent was. And it'll be very interesting to see how much has to be rechewed or taken back if there's going to be now an appeal to Europe. And yeah, so I think that this is I'm often asked, well, would you make the deal and take the German system to just end all this? For example, in Germany, you have to have counseling before you can have permission to have an abortion. But the fact is, once you have counseling and you can choose which kind of counselor you go to, you then get a certificate and you may then go and get the abortion. And it's very hard to explain to people outside the US that counseling here would look nothing like what it looks like at least in Western Europe, we would have, I can't imagine neutral counseling in the US. I mean, I can see religion getting involved very quickly. So it's a hard question that you asked, and to see how it's played will be curious.
Thank you.
Mm.
But we need to let you go. I'm sorry. We'd like to go longer, so maybe we'll do another one of these sessions. But this has been just fantastic. I want to thank all of my colleagues for being brief, but really just teeing up a set of really important questions for us. I don't know what just happened. Oh, there's Lilia's information. And since I'm not teaching on Zoom anymore, I've completely forgotten how to use it. We're going to take the cases that each of us have mentioned and put them into a little reader. And my hope is that this would be a kind of model for what other law schools could do as well, to teach this material. We could also teach a whole set of other really important issues that are going on in the world right now through the first-year curriculum, and maybe we'll do that. But if you're interested in the cases, we will share them with you all through an email about where we posted them. And I just want to thank you so much for coming, for listening, for your engaged questions, and again, to my really smart colleagues for bringing their courses to bear on this set of issues. So thank you.